SJC-11450, Matthew Ferreira v. Chrysler Group, LLC, and another.
Yes.
Good morning, Chief Justice Ireland and Justices of the Court. May it please the Court, my name is Sarah Judge, and I'm from the law firm of Burns & Levinson. With me today is Attorney Paul Harris, and together we represent the appellant, Somerset Auto Group, that operates Somerset Chrysler Jeep Dodge in Somerset, Massachusetts. I've spoken with the clerk, and I'd like to reserve 3 minutes for rebuttal today. This appeal involves an issue of first impression before the Court, involving the interpretation of Chapter 93B, which is the statute that regulates the relationship between motor vehicle dealers and motor vehicle manufacturers doing business here in the Commonwealth. The issue before this Court is, when is the manufacturer's duty to defend the dealer triggered under Chapter 93B, Section 8A? Does it trigger when notice of a covered claim is given by the dealer to the manufacturer, or is it only triggered when the final determination of liability has been adjudicated against the manufacturer?
Judge, what if, because 93B also has a Section B, which is the mirror image, so what if the purchaser of the vehicle brings two claims, one of which directly implicates the manufacturer and the other of which directly implicates the dealer? How do you do that?
Well, that's similar, actually, to this case. You have to look at the
This
complaint.
one, it's all combined. I mean, it's
Yes.
not, both parties are named as responsible for, as I gather, every single one of the claims that Mr. Ferreira made.
You're correct, Your Honor. The complaint does allege the same claims against both parties here, but you have to look at the crux of the complaint to see what are the claims going towards. And here, it was the defective manufacturer, a defective product. You're correct that
Oh,
8B...
I thought there was allegations of failure to repair correctly.
There are, and it's failure to repair a defective product.
Yeah,
But
well.
you're correct that 8B allows the manufacturer to say, no, dealer, the problem is your problem, and you made the mistake here. And so what they would do is they would invoke their right to a defense against the dealer, and you would have the dealer and the manufacturer asserting claims, basically, cross claims against each other, saying it's your fault. No, manufacturer, it's your fault.
Well,
That's not.
doesn't
And
that
then in the cross claims.
I'm
Are
sorry.
they going to defend each other in the cross claims?
I mean, well, let me ask you this. This is a separate question, but with respect to just the arrangements between manufacturers and dealers, I'm sure it's in the record, I didn't look yet, but and there are indemnity provisions, contractual indemnity provisions, correct?
Correct, Your Honor, yes.
So do they ever, those contractual indemnity provisions, provide, for example, that the dealer is going to be responsible if a person who has bought the car sues, and the dealer and the manufacturer are named as defendants, the responsibility to indemnify and to defend is going to be the dealer's.
Well, every manufacturer has its own set of contractual obligations.
Right. But does that sometimes happen?
It's possible, yes, that depending on the type of claim. That's why Chapter 93B, 8A, and 8B say, notwithstanding any contractual provisions to the contrary.
That's what I was getting at, because couldn't one read that second sentence as really referring to that? In other words, saying, notwithstanding the fact that you may have a contractual provision that says, Mr. Dealer, that you're responsible for defending, for assuming the defense of this claim, notwithstanding that, we, the legislature, are going to say that if it's really about the negligent manufacture of the car, or breach of warranty for the manufacturer, then you got to assume your own defense. And then we'll deal with the indemnity for damages and who ultimately pays attorney's fees thereafter.
I just want to make sure I understand. Are you referring to 8B when you say that the second section?
I'm saying the second sentence of, well, it's the second sentence of both 8A and 8B. That is the one that we're dealing with here,
Yes.
about assuming defense.
The sentence you're referring to reads, "The manufacturer or distributor, after having been notified promptly in writing by the motor vehicle dealer that the claim has been asserted and is pending, shall assume the defense thereof and resolve the same at its own expense." And Somerset's position is that that sentence refers to the claim which has been described in the prior sentence, which would be the claim that's predicated upon the negligent design or manufacture of the motor vehicle. When a dealer receives a claim or is brought on, a claim is asserted that is predicated upon the negligent design or manufacture of the vehicle, the dealer is entitled to demand defense as well as indemnification, two separate rights under Section 8A.
Well, if that's the case, then what does the language mean in the first sentence that if ultimately it is found that it's only the negligent manufacturer design, then the manufacturer is responsible for expenses of suit, including reasonable attorney's fees arising out of or incurred in the defense of any claim. On your reading, that already would have been covered. So why say it twice?
Your Honor, I believe that language acknowledges the procedure that's set forth further below in 8C. So we have three provisions in Section 8. There's 8A, which we're discussing, which is dealer saying to manufacturer, "Hey, manufacturer, you're responsible." There's 8B, where the manufacturer has the right to say, no, wait a minute, dealer, it's your responsibility.
I'm sorry, finish.
Then you have 8C, which says that either party, dealer or manufacturer, has the right to assert a claim in superior court for indemnification. And indemnification, if you go back up to both A and B, they talk about what's indemnified. You're indemnified for the losses, the costs, and the attorney's fees. It sort of scoops up all of that package, and that's the...
If you have been found, if there has been a judgment finding that the other party is solely responsible.
Correct. It's sort of the catch-all for if you have a situation where both the manufacturer and the dealer are pointing fingers at each other. Practically speaking, both parties are not going to start paying each other's defense costs while they're both in litigation against each other, even though under these A and B, they both have rights to seek those defense costs.
Yeah. When I read that, and tell me if I was wrong, the clause, hold harmless from and against all damages, liabilities, losses, and reasonable expenses of suit, including reasonable attorney's fees, that all of those items are plaintiff's damages, elements of a plaintiff consumer's damages, so that the reasonable attorney's fees and costs are, in effect, 93A attorney's fees. But you're saying that it's really the costs of defense.
I think it'd be interpreted the way you're arguing, the way you're stating, Your Honor. I think that you do have claims where a plaintiff may be entitled to an award of attorney's fees. And I think that would, you could interpret the losses and attorney's fees there to encompass the indemnification of losses. I don't think that's an unreasonable interpretation. The statute's not...
Incurred in the defense of mean, then, in the next clause.
Well, in that case, including, let's see, hold harmless from and against all damages, liabilities, losses, and reasonable expenses of suit, including reasonable attorney's fees arising out of or incurred in the defense of any claim brought by any person seeking compensation or other relief predicated on the negligent design. I think that you can interpret the statute more broadly, as Justice Spina suggests, in terms of that if the losses include attorney's fees, then it can be interpreted in that way. I think that, going back to my original argument, that I think it's an acknowledgement that you have a statutory structure that is the product of compromise between powerful interests, dealers' lobbies and manufacturers' lobbies. And they say, look, it can't be all one way with dealers' rights. The manufacturers want rights too. So they negotiate this out. Well, whatever rights that Chapter 93B provides, that whatever rights the dealer has, well, in that turn, we're going to give the manufacturer the same rights. But you have an issue, and that's addressed in, I think, in 8C, which is if both parties are pointing the finger at each other it's not practical from a realistic sense that they're going to start submitting attorney's fees bills to each other during that part. I think that the Section 8A, which talks about that, Section 8C says you can bring a claim into Superior Court for indemnification. And when you go back to what is indemnification, well, it encompasses everything. I think we have to give meaning to that last
Stop you
sentence.
there. I mean, that's what it seems to say. It does encompass everything. So that I understand your argument. There, even though it looks facially fair that both parties have a right of defense, I understand that. Ultimately, the legislature, this language seems to say, okay, you both have a right. And if the manufacturer takes the risk, doesn't actually engage in the defense, just says, well, as they said here, we don't do that until there's an actual lawsuit, and then you've got 3 days. They can take that risk because they actually don't incur the actual liability, the indemnification of those costs until you prevail by judgment, right? So that's... And so what you're saying is that's where the unfairness is. But maybe that's in the language. I mean, right?
Well,
That seems to be the language. So if we're there, if we say, yes, that's what this means, they didn't defend, that's bad, but they only are recovered, you only get recovery ultimately if there's a judgment in which you prevail, right? But let me go back. How would you, didn't they actually defend? At some point, I mean, there was at least, the findings by the judge said that there was a 93 response. Is that not true? Is that an inaccurate finding?
Well, in this case, Somerset defended itself throughout the entire litigation. Chrysler's never picked up the defense for this case or
It
stepped
says in
in.
the findings that there was a 93 response from Chrysler.
Oh, yeah, Chrysler had its own attorneys, and they,
To Ferreira, right?
Yeah,
yes,
that's what it says.
absolutely, Your Honor.
They responded
Both
to the
parties
93A?
engaged their own counsel to
Okay.
respond to the 93A. My firm represented Somerset in that and drafted a response, and Chrysler, they had claims against them. They had to
Right.
hire
So-
attorneys, and they went on it on their own, so to speak. So I think, but you have to give meaning to that last sentence. And I think the most important language in that last sentence, the last sentence is just as important as the first, is that it's a shall assume the defense and shall resolve the claim. How can you?
So let me ask you this. Does that mean that if you... So if you assume the defense and you have here, you've got a judgment that doesn't make Chrysler responsible, then do you pay it
Your Honor,
back?
I think I understand Your Honor's concern. I see I'm short on time, but I can quickly address that. I think what you're trying to say is, well, why should Chrysler have to assume the defense of a claim that ultimately they weren't responsible for? And I think that goes to the public policy is who has control over this product? A dealer is required by a contract to sell whatever is given to them. The manufacturer is the entity and the party that is in the best position to defend against a defective product claim.
Well, isn't that essentially an argument that says that implicit in what the legislature is doing is that when the dealer is brought in only because it's being viewed as vicariously liable for the conduct of the manufacturer covers the defense, and when the manufacturer is being brought in because vicariously because of the conduct of the dealer essentially bears the defense? Isn't that the best way to interpret this?
Well, I think that you have to look at this in terms of, again, as opposed to vicarious liability. I believe that most plaintiffs, in my experience, will just try to get as many people to the party
Right,
as
but some people are
possible.
liable not because of what they did, but because of their relationship to somebody else.
Sometimes, and that's not this case, because Somerset sold this vehicle initially, and then it was repaired by various other dealers as well. But I think the important thing to remember here is that it's the manufacturer that controls the product, and that's evidenced by their expert witness. There wasn't some outside expert that they hired. It was,
You know, let me
Yeah,
interrupt. You're coming back again on rebuttal, right?
I am, Your
So
Honor, yes.
Maybe we should stop here. Please.
Thank you.
Next counsel.
Well, good morning. May it please the court, my name is Keith Brian Rose, the Rose Law Firm. I represent the defendant, Appellee, Chrysler Group, in this matter. I'd like to start off saying, as I was sitting there, that I am good with some of the questions or responses or interpretations that the bench gave of this statute, because I think that from the questions, our interpretation of the statute may be very much in line with some of the suggestions from the bench. But let me reiterate a couple of things, and that goes as follows. I mean, we start with the general premise that this is a question of statutory interpretation. And this court has always said as a general rule that when one interprets a statute, it does not take one sentence in isolation, but instead looks at the language of the statute in its totality and harmonizes the various provisions of the statute. And what the appellant seeks to do is take one sentence from one subsection of the statute, and from that one sentence and one subsection, create some independent duty on the part of the manufacturer to provide a defense, notwithstanding any of the other language or any of the other conditions with respect
The
to...
difficulty with your interpretation, though, is the second sentence doesn't matter. It becomes irrelevant. In other words, if you, at least as I understand what you're saying, in a case such as this, where your client is not found liable, summary judgment is entered against the car owner, you don't have any responsibility, right?
Well, I would suggest and completely disagree with the concept that our interpretation makes that second sentence completely irrelevant, because, in fact, what that second sentence does is provide an obligation on the part of the dealer when it seeks indemnification/defense from the manufacturer, or, per subsection B, exactly the reverse, to promptly notify in writing of that request for indemnification
Well, then,
and defense.
If that's what they, and that's what its purpose is, to make sure you, well, then why go on and say, and the manufacturer shall assume the defense thereof and resolve the same at its own expense? Why add that?
I think the purpose of that section or that sentence, Judge, would be in the event that there is no notice, in the event that Somerset, for instance, in this case, were simply sued and the matter proceeded with Somerset defending the claim through verdict, and after verdict, then looked to the manufacturer for defense, that sentence would prohibit any obligation on the part of the manufacturer to indemnify or to pay for any of those defense costs because they were not given prompt written notice of the claim. And yes, you are correct that part of that sentence also suggests that they are obligated then to assume the defense. But that also sets a timeline for when the duty to indemnify and hence the costs incurred as referenced in the provisions of the statute above would start to accrue.
Doesn't assume the defense mean, in common parlance, you take over the representation of the party?
I would suggest that it does, but you cannot read that phrase in isolation without looking at the other language of the statute.
But I mean, isn't this exactly the type of case in which you should have taken over the defense because it was your defense?
No.
It was your expert. There was nothing about what Somerset did which caused you to win. I mean, it was what you did in this case.
When one goes and looks at the pleadings and the complaint filed by the plaintiff, the complaint filed by the plaintiff alleges that they purchased a vehicle from Somerset. They allege that the vehicle was defective. They allege that both Chrysler Group and Somerset made various misrepresentations to the plaintiff, that in addition to the misrepresentations which gave rise to a 93A claim.
Well, the misrepresentations were that the vehicle was fine, was as manufactured, right?
That's right.
So isn't that all about the manufacturer?
But they also...
warranted.
But they also asserted that there was a failure to repair the vehicle or timely repair the vehicle, giving rise to a claim for breach of warranty.
The essence was that the problem was a design defect, no?
No. There is, and this court has been very clear with regard to the economic loss rule. This complaint did not allege personal injury. It did not allege property damage. It simply sought a refund of the purchase price, and this court has been very clear.
The vehicle that was sold, brand new vehicle, we're not talking about used vehicles here. The vehicle that was sold was defective, that's your problem, and the dealer failed to repair the defects that are yours. So why isn't this all about you?
Because that gives rise to separate and independent allegations against the dealer and obligations to the dealer for both breach of express and implied warranty. Moreover, may I add that one of the provisions of this statute very specifically indicates that the duty to defend and indemnify is a duty which arises for negligent design or manufacture. And just to circle the wagons back around, this court, in determining the economic loss doctrine, has said that when the damages sought are solely economic loss, that does not give rise to a tort-based breach of warranty claim. I mean, the essence is not simply to look at the phrase breach of warranty, this court has said, but to determine the nature of the breach of warranty, whether it is a tort-based breach of warranty, which would give rise to a negligence claim, or a contract-based breach of warranty claim, which would be an economic loss claim. And the statute was designed solely and uses the words negligent manufacture or design, which are tort words, in a case which never raises any
I'm sorry, you're going to
tort
have to go
issues.
back here. This is confusing me. So you're saying what? That this is not a case even contemplated by this statute?
That's correct.
So
What I am
this
saying
has
is-
nothing to do with Section 8A or Section 8B?
Yes, what I am saying is that one of the prerequisites of this statute, and if I just may have 1 second. Statute only applies to claims, quote, predicated upon the negligent design or manufacture of a new motor vehicle. And the appeals court in the Mansell case discussed that exact phrase and held that a purchaser of a product who claims as damages only economic loss or damage caused by the product itself cannot maintain a claim, quote, for negligent design or manufacture. And this court, in looking at...
So this is a breach of warranty claim?
That is correct. And it's not just solely a breach of warranty claim, Your Honor, because you've looked in terms of the UCC and the statute of limitations, but you looked and you said you can have a tort-based breach of warranty claim when the damages sought are personal injury or property damage, which is what we would suggest this statute applies to, or you can have a contract-based breach of warranty claim when the damages sought are solely economic loss. Here, the damages sought are solely economic loss, which makes this a contract breach of warranty claim, not a tort-based breach of warranty claim, not a claim for, quote, predicated upon the negligent design or manufacture of new motor vehicles. So we would submit that 93B is never implicated based upon the pleadings of this claim.
I'm sorry, I don't understand. If the gas gauge, is that what we're dealing with here?
Yes, fuel gauge.
Fuel gauge, it wasn't
Working right.
recording correctly, or wasn't measuring correctly.
Yes, ma'am.
Why isn't that a claim about negligent design or
Because
manufacture?
if that fuel gauge had caused an explosion causing personal injury or property damage to damage other than the vehicle itself, then it would be a tort-based or negligent manufacturing or design claim based upon the holdings of this court. If instead the damages sought are solely for the cost to repair that defective gas gauge or the cost diminished value of the vehicle or a refund of the vehicle's purchase price, economic loss damages, this court has said that under the economic loss rule is a breach of warranty claim, it is a contract-based breach of warranty claim, and therefore tort rules, negligence is not implicated. And the statute discusses negligent design or manufacturing. The complaint in this case doesn't seek personal injury or property damage, only seeks economic loss.
So your argument is that this would go only to a classic tort case?
That's
That
correct.
The car explodes, somebody's injured. It does not go where there is a product defect, which is the source of a claim of breach of warranty,
That's correct.
either implied or actual.
Yes.
Is there anything in the legislative history which indicates that the legislature did not mean this to apply to the more classic breach of warranty, the more classic lemon law type of claim?
There is an absence of legislative history with respect to this section, Your Honor, so the answer to that would be no. But I go back to the plain language of the statute, and on more than one occasion, in addition to suggesting that these claims have to be, quote, predicated on negligent design or manufacturing, the statute further talks again about negligence, where it says,
Well, I mean,
where it's determined-
a product defect may be from negligence. It need not be from negligence, but it is still a product defect.
The plain meaning of the word negligence as offered by this court is a situation where there is a tort-based claim. Negligence is a tort concept which suggests personal injury or property damage other than the product itself. And this is instead a classic economic loss case. And this court has made clear that the Commonwealth, in line with majority states outside of the Commonwealth, recognized and has recognized for many years economic loss rule, and has said that that is quite different than tort-based or negligence-based concepts. And the court, the appeals court, in fact, used those exact words in the statute and related it to the economic loss rule in the Marcel case.
Now, your sister says you lost as to that issue in the appeals court, and it was only they who sought further appellate review, and therefore you're barred from making that argument here.
Well, that would be a very good argument, except that this court has repeatedly held that when this court grants further appellate review, the court reviews all issues that were before the appeals court, and review is limited to a specific issue only where the order allowing review states such limitation. And the order allowing review of this case had one word. It said allowed. There was no limitation with respect to the issues, and the argument that I'm making before you was one of many that were made and were briefed in the appeals court, which is before you, which the appeals court decided it need not address because of its holding with regard to the fact that before we could be responsible, it had to be predicated on a verdict showing that my client was 100% at fault, and in this case, that could never occur because when we moved for summary judgment, the holding of the court was we were not at fault at all, and then subsequently, Somerset and the plaintiff entered into a voluntary dismissal. So there could never be a finding under 93B, assuming it was applicable, which we submit it's not, but there could never be a finding that it was predicated, that indemnification, which needs to be predicated on a finding that we were 100% responsible, could ever occur. And that's the basis of the Court of Appeals. The appeals court ruled in the manner it ruled and never reached the other issues.
Now, if I could turn you back to the last sentence, assuming the defense, implicit in that is that there would be a joint defense?
Well, I mean, here's the why the construction offered by appellant is illogical. The statute provides that same last sentence in both subpart A and subpart B. Therefore, if that sentence creates an independent duty, which is what is the suggestion of sister counsel, that the manufacturer defend, it likewise would then create an independent duty for the dealer to defend.
So then don't we look at the essence of the claim? Let's assume we can get over this. Let's assume we had injury here. The fuel pump, whatever gauge, was inaccurate. It caused an explosion. So we're in the ballpark. Even you would concede we're in the ballpark here.
Yes.
But both dealer and manufacturer were brought into the case for obvious reasons. But the essence was clearly a design flaw. Shouldn't we look at that to determine who defends?
Well, and I think the reality in the business world is that looking at those pleadings and putting aside the dealer sales agreement and looking solely at the statute, it likely would be that if the dealer requested indemnification and defense, it would make business sense for the manufacturer to assume the defense because they would want to jointly defend that matter and not have the dealer as an adverse party. That being said, the obligation under the language of the statute is if, for whatever reason, the manufacturer requested that the dealer defend, or the dealer requested that the manufacturer defend, and both said no, the remedy per the language of the statute is you're entitled to recover should there be a judgment finding the manufacturer 100% at fault when the dealer is requesting indemnification, or the opposite way, when the manufacturer is requesting indemnification, then you get not only what the plaintiff has recovered against you in that judgment, but your cost of defense. So the risk either party takes when they review the pleadings in saying no is they end up paying for two lawyers, their own, plus if there's that verdict, they also then have to pay not only the judgment, but the other side's attorney's fees.
Well, in the insurance arena, I mean, it's often the case that it might be unclear whether there's a duty to indemnify, of course, and a duty to defend. It may be unclear whether this falls into the duty to defend area, and we've said insurers really need to go and get a declaratory judgment if they're not going to defend.
Yes.
And it really, you look at the essence of what's alleged to determine whether it comes within the policy.
Yes, and I would suggest to you that that situation is not present here, A, because of subpart C, which specifically provides that an action can be brought or a cross-claim or a counterclaim with respect to indemnification. So the legislature...
Indemnification is, I rather like to think of these as two things. The duty to defend is different than the duty to indemnify.
Okay. But in the essence of the statute, which unlike in the insurance realm where, at least with general liability insurance policies, there is a separate duty in the policy language to defend, provided that the allegations come within the policy terms, right? And
Why
you
isn't
are-
this exactly what this says here?
Well,
Now, let me just interrupt. You're going to have to wind it up
Yes.
so you can finish the answer, and then your time is up.
okay. Let me try and get back to this. The policy language in the general liability sphere specifically has a duty to defend, which is policy-based. And this court has said that a declaratory judgment action, when that does not occur, would be an appropriate avenue. Here, the general liability policy language is completely different than what is provided in the statute.
Thank you.
Thank you, Counselor.
Thank you.
Rebuttal.
Thank you, Your Honor. On rebuttal, I'd like to quickly address the argument raised by Chrysler regarding the fact their claim that this claim doesn't even fall within the purview of Chapter 93B. The crux of their argument is that the claim is not predicated upon negligence, and therefore it shouldn't even be before this court. That was the dispute in the Superior Court, and Justice Moses had found that the claim wasn't predicated upon negligence. That was the focus of all the briefing at the appeals court level, and the appeals court did address this issue in their decision, and I'd like to guide the court to footnote 2 of the appeals court decision, which is a clear copy is attached at on the back of Chrysler's brief in the addendum, and it's important because they didn't ignore this issue. It says, the statute furnishes a right of indemnity for losses arising out of any claim, quote, predicated upon the negligent design or manufacture of a new motor vehicle or any part or component thereof. A claim that a product is defective typically encompasses such a claim, regardless of whether it uses the word negligence. Such a claim may, however, be framed as a breach of warranty claim rather than a tort claim, and must be framed so if the economic loss, the loss of the defective product or use thereof, is the only damaged claim. And the appeals court cites to SJC case law on this issue. It says, the construction of the statute that Chrysler Group urges would significantly undermine the primary purpose of the statute. And the primary purpose of the statute is actually a consumer protection statute. The Tober case that's cited by the appeals court and is pretty much the most cited case on 93B, talks about how it is important for dealers to have a strong dealer body so that consumers have access to warranty work and repairs, and in essence, protecting dealers protects consumers. The appeals court did address this issue. This issue is, the counts and claims by Ferreira are predicated upon negligence, and Justice Gantz was correct that that issue has never been appealed. But even if the court wants to relook at the issue, the appeals court got it right. Predicated is in the statute. The statute is nothing in the statute limits the claims to explosions and torts. It's about defective products. And who is the party that best controls the product here?
Can I ask you a question? The statute in 8A has the first sentence that's talking about the right shall indemnify and goes what will be indemnified in certain conditions. And then in the second sentence talks about assume the defense. And then 8C says any person entitled to indemnification under this section. So the word indemnification, one might think, ties back only to the first sentence of 8A, no? Why does the second sentence become indemnification? Do you see what I take it you are saying that, you have said this, that 8C gives a dealer in your situation the right to seek, obviously, indemnification if that's the way the judgment came out, but also these costs of defense, correct?
Correct.
And I'm just asking you, given the way indemnification is distinguished from defense in 8A, why doesn't the use of the word in 8C be limited, why isn't it limited to that first sentence of 8A?
Because the first sentence in 8A includes, within the scope of indemnification, seeking attorney's fees and costs. So going back to the structure of how these three provisions work together, I should remind the court that in this case, Chrysler hasn't invoked 8B. That's not in play here. But with 8A, the dealer says, I demand a defense, and the statute says you must assume it and resolve it at your own expense, Chrysler. Now, if they don't do that, it says under 8C, the dealer, here Somerset, can sue for indemnification. Well, going back to that first sentence, well, what is indemnification if you have to actually sue? Well, you can go after your losses. Well, what are those losses? Well, losses that are incurred because I was found liable, including attorney's fees and costs. So indemnification in that regard encompasses the whole picture here. In other words, you can go and be reimbursed if you seek indemnification under 8C. Either party, you can be reimbursed not only for just the losses, but for the attorney's fees. And that makes sense. Why? There would be no incentive. To interpret the statute otherwise, there would be no incentive for a manufacturer, for a clearly defective product claim that has no other claims against a dealer individually, to assume the defense. And
But what happens if the jury or the judge determines one of two things, or both? A, that the plaintiff in the case perhaps misused the product and the plaintiff itself was 10% negligent, or if Somerset, in the course of dealer preparation, contributed to the product and was 10% negligent. What happens to the indemnification?
Well, there, if you have a situation with the cross claims for indemnification, both under subsection A and subsection B, the parties are actually asserting affirmative claims and have to prove their case. You're turning dealer against manufacturer and vice versa. From a practical standpoint, I would recommend to my client that the dealer and manufacturer should try to have a united front against the products. I mean, it's in the dealer's interest. They're selling these products. They don't want to be in court saying they're bad, we're selling bad products. And likewise, for the manufacturer, this is their product. They can stay their claims with respect to the cross claims and toll them and say, look, let's present a united front, on this case, and we'll reserve our issues, and we can battle those out in a separate court case if we want. There's nothing saying it has to be brought in as part of the same trial. Or I've had cases, Your Honor, where it was clearly that the issue was clearly the allegations were clearly against the dealer in terms of it was an issue about an aftermarket product, and what that is where the car comes to the dealership installed a fancy GPS system. Manufacturer says, well, your fancy aftermarket GPS ruined the electrical. We're saying, no, it was a problem with the electrical. Well, that's a case that can actually be heard as part of the product defect case. It's always fact specific as to what trial strategy you do. But the fact remains that if it's nothing, and Judge Gantz was spot on with this in terms of the expert at the summary judgment level never said, hey, this was, they failed to repair. They said everything is working as designed. There's nothing in the record that shows that Somerset did anything wrong. And that's exactly why Chrysler didn't bring an 8B indemnification claim. That's not an issue in this case.
Ms. Judge, your time is up.
Thank you, Your Honor.
We'll take our morning recess.